Welcome to this Legally Disabled Roundtable. My name's Chris Seal. I'm a Diversity and Inclusion Advisor here at the Law Society. During spring and early summer 2020, the Law Society, the Legally Disabled Researchers and the Law Society's Lawyers with Disability Division hosted a series of 7 roundtables to discuss the findings of the legally disabled research, take questions on it, and then discuss the way forward with actions. This is a specially recorded version of the roundtable with members of the committee of the LDD to discuss some of the issues that arose during those roundtables. As well as myself, the speakers today will be Debbie.
Hello, my name is Professor Debbie Foster, and I'm Professor of Employment Relations and Diversity at Cardiff Business School, Cardiff University.
Natasha.
I'm Natasha Hirst. I'm the independent researcher working on the Legally Disabled project with Debbie at Cardiff Business School.
Jane.
Hello, I'm Jane Burton. I'm Chair of Lawyers with Disabilities Division.
And Sarah.
Hi, I'm Sarah Longett, and I am a D&I advisor at the Law Society.
We're going to put everyone on mute for the purposes of the presentation, and then we'll unmute people for roundtable discussion. If you've got any questions in the meantime, you can put them in the chat because myself and Sarah will be monitoring that throughout. We're going to hear about the findings. Jane's going to say a bit about collaborative working. Then we'll take questions from those people on the roundtable on the findings, and then move on to some easy wins and actions that people can be taking. So now we go to Natasha and Debbie for the findings.
Okay, so as I said, I'm Professor of Employment Relations and Diversity at Cardiff Business School, and the money for this project was secured from Disability Wales through something called DRILL, which is Disability Research for Independent Living and Learning, which was an innovative project bringing together disabled people's organisations and academics for the first time to produce some brilliant research in this case. So the aims and objectives of the research project was to first establish a comprehensive evidence of the experiences of disabled people working in the legal profession. And the reason why myself and Natasha chose the legal profession was because we were very aware that the legal profession had done a lot of work on diversity and inclusion, but particularly around issues of gender and race and LGBT+, but we couldn't actually see anything at all on disability. And it's also the case that quite a lot of research is focused on disabled people getting into the labour market at the bottom end of that labour market, rather than thinking about disabled people getting into long-term careers. So this is the motivation for looking at this research. And we wanted to co-produce the research with disabled people so that their voices and their priorities would be fully represented. The whole idea of the research was to challenge negative stereotypes and limited aspirations, to highlight untapped talent amongst disabled people and necessary obstacles, and also to work with stakeholders like the Law Society to bring about change. In terms of the methodology, we used a methodology called co-production, and that is working with a disabled people's organisation, or DPO. We were guided by the social model of disability, which sees the problems of disabled people really located in society rather than in their medical condition. And we worked with our partner, which was the Lawyers with Disabilities Division of the Law Society, as well as establishing a research reference group. And the reason we did that was the Lawyers with Disabilities Division only represent solicitors in England and Wales. They don't actually represent all groups within the legal profession. And because law is a very permeable profession, i.e. people go into the profession and they may end up being paralegals, solicitors, or they may go on to become barristers, we thought it was really important to capture that permeability between different career routes. So we had some barristers and some paralegals and some other representatives on that research reference group to also align with the LDD. Now, our methodology was first set up with focus groups, and focus groups are often used as a way of feeding back research at the end of your findings. But we wanted to use focus groups in a way that would enable us to really identify the issues from disabled people working in the profession and their perspective. What issues did they think were really, really important to them, without us thinking we could impose what we thought was important on them as academics, because that's often the case, that academics come to research and they've already done lots of background reading and they think they know the issues. Well, we didn't want to do that. So we held 8 focus groups across England and Wales, and then we looked at the themes that arose from those focus groups. And those key themes then shaped the questions we asked in semi-structured interviews. And these were individual interviews with 55 different disabled people in the profession. And we conducted these either by Skype, face-to-face, or by telephone, according to people's availability. The interviews lasted for between 1 and 3 hours. So we collected a lot of really, really rich data. And we took a sort of biographical approach. We wanted to know why people had come into the profession, what had motivated them to come into law, whether they had already had an impairment when they came into the profession or not, whether they developed an impairment while they were working, and what were the sort of obstacles that they had encountered, or opportunities that they had encountered as disabled people. And at the end of the interviewing, we analysed the transcripts from the 55 interviews, and this shaped our questionnaire. And we wanted a questionnaire because we thought, well, there's a lot of detail in the interviews, but we also knew that policymakers and organisations look at headline statistics. So we used this mixed methodology for that reason. And we had 288 people respond to the questionnaire. We did a slightly different questionnaire for barristers, and we did one for solicitors and paralegals because the issues varied very slightly between them.
With the key findings, it sort of settled into 3 main areas, which was getting into the profession, progressing, and then reaching senior positions, so really getting on in the profession. There were a lot of issues for people trying to get into the profession, so graduates and people coming in early on. But there was a group within that who really stood out, who we termed as chartered litigants. So this was a group of people who had, maybe through injury, medical negligence, been involved with their own personal cases during their childhood, which had brought them into contact with the legal profession. So it had given them contacts, it had given them a sense of what happens in the legal profession, how things work, and it also gave them the sense of, oh, here's something that I know about, that I understand. This is something that I could do as a career. So it gave them that aspiration to pursue a legal career. And it also gave a number of advantages through having contacts and being introduced to the profession. It gave opportunities to get work experience and to build up a CV in a way that gave them a little bit of an edge coming in. And we found that these advantages also cut across socioeconomic background. One of the other things that was really interesting was that this was a group that tended to have a lot of support and a lot of different resources around them. So they had people who were saying, you can do whatever you want to do, you can be whatever you want to be. And especially where they'd had a very supportive experience of education, where all the reasonable adjustments that they needed had been put into place for them. They went on into the world of work with the knowledge that there are solutions to the barriers that they face, and with that expectation that those solutions can be put into place for them. And it also gave them a lot of confidence to advocate for themselves when it came to talking to employers and colleagues about their impairment and about what their needs were and what solutions that there were to enable them to come in and just get on with doing their job in the way that they wanted to.
Thanks, Natasha. As Natasha said, securing training and employment was one area that was really important in our findings. Getting into the profession and actually getting some work experience, getting training, was a real problem we found for disabled people. We also found that a much higher number of people actually already self-identified as disabled before they actually went into the profession, because there's this perception in law that people have acquired impairments as they get older. But actually 66% of barristers and 59% of solicitors and paralegals that we surveyed were disabled when they started their training. However, those identifying as disabled at the point of application reported being most disadvantaged while applying for training or employment. And that obviously has implications for declaring and self-declaration of disability. Only 9.7% of disabled solicitors and paralegals reported a positive and supportive response when using legal recruitment agencies. Now, this was a particularly damning finding, that only 9.7% of people actually found these agencies positive and supportive. And we heard from interviewees of instances where they would contact an employment agency and be told there were jobs available, and as soon as they declared that they were disabled, those jobs were no longer available, or they were sent to an employer to be interviewed, having declared that they had accessibility issues, and only to arrive at a building that they couldn't actually get into. And these are really, really basic things that should have already been sorted out. And we're also worried about the fact that there's a lot of contracting out of recruitment within the legal profession, which means that even if companies and organisations are getting it right on recruitment at the D&I stage, that, you know, their contracting out is actually undermining all the work that they think that they're doing that's positive in this area. We also found that fewer than 7% found it easy to find out about the accessibility of a prospective employer. And, you know, simple things like the layout of a building, the accessibility of lifts, whether wheelchair users can enter a building. These are things that could be signposted quite easily by prospective employers or trainers, but they are still not being done. You know, many years since 1995, which is when the Disability Discrimination Act came into force. 60% of the people we surveyed were concerned that inaccessible working environments limited their opportunities, and the comparable figure for barristers is 50%. We found a lot of people having to do research in advance of going for interviews, which might mean visiting the premises in advance or finding out about the employer and their accessibility and their attitudes. And, you know, employers should be warned that a lot of talented disabled people out there are sifting out potential employers because they're saying, you know, I can't see any evidence on their website or at employment fairs that these people are making an effort and being accessible to disabled people.
Okay, so with the data, we found that over 90% of survey respondents had a non-visible impairment, and that's really significant because it means that an employer isn't necessarily going to know that somebody is disabled or that they might need reasonable adjustments unless that person tells them. And we also saw that 50 to 60% disclosed their non-visible impairment when applying for training, jobs or tenancy, but the majority that could not conceal a visible impairment still concealed a non-visible one. So for example, wheelchair users who obviously had to declare that in order to be sure that they could access a job interview or work in a particular office, would still conceal other issues such as fatigue or other conditions that they had. And what that points to is that a lot of people are afraid of being stigmatized if they make their impairments known to an employer or potential employer. And unfortunately, our research shows that a lot of people who do disclose have a bad experience as a result of doing so. So people are right to be concerned about disclosing. But it also shows that employers are not being proactive about creating an environment where people feel safe to talk about their impairment and to talk about what adjustments could be put into place to enable them to fulfill their potential in doing their job. And even with anonymous equality monitoring surveys, only 60% of solicitors and paralegals and 55% of barristers were willing to disclose that they are disabled. So that's anonymous. So it means that people are not understanding why that data is being collected, how that data is being used. And employers need to be really clear that this is something that can benefit individuals, because it enables the employer to know that they do have disabled people in their workforce, and that they might not be getting all of the support that they need to do their job.
Yes, in terms of career paths and progression, as well as getting into the profession, getting on and getting up in the profession were part of the considerations that we took into account when analysing the data. Because unless there are disabled people in senior positions within the profession, a bit like in the past we've talked about women and that leaky pipeline, you know, that pipeline into more senior positions, unless there are people there who can act as mentors and role models, then it's really difficult for disabled people to progress within the profession. And we found that career paths in the legal profession for disabled people were more precarious and unpredictable, with barriers such as, you know, accessibility and location of premises. People talked a lot about having to travel to and from work and the sheer exhaustion that took. And, you know, the sheer exhaustion surrounding accessibility of transport and location, and just, you know, that effort of getting to work every day. Rigid working practices that failed to facilitate reasonable adjustments. There were some really, really simple adjustments that could have been made and are recommended by bodies like the Equality and Human Rights Commission as established reasonable adjustments. For example, allowing people to travel to and from work out of rush hour. So a slightly later or slightly earlier start for somebody, or a slightly later or earlier finish for somebody. And, you know, that can make a huge amount of difference. But also working from home. Home working was one of the most requested reasonable adjustments that we talked to people about. And it was also one of the most commonly refused reasonable adjustments. And I think that the whole experience of COVID-19 will have to be reflected on by the legal profession. And hopefully we're anticipating much more accommodation of home working as a reasonable adjustment in the future. There were often health-related career interruptions, which actually we would classify as sometimes unnecessary. People could have continued working, they could have worked in a different capacity, they could have worked from home, they could have worked part-time. That continuity and support at times when maybe they needed medical treatment, or, you know, a lot of people had unstable impairments where some of the time they would feel able to work full-time, but other times that they couldn't fulfill that full-time job, and they weren't supported in that kind of flexible type of employment. And that can have an enormous effect on your career trajectory. Expectations of physical networking was another area we heard a lot about from people. Some people felt that if they couldn't do the physical networking, then they didn't have the criteria for promotion, for example, and that comes under the next thing, unnecessary essential criteria. But there were also simple things that people pointed to, that they perhaps could do more networking if the event that they went to catered for wheelchair users or allowed people to sit and put drinks down, because of issues to do with standing all the time that can affect disabled people. These are just really, really simple, easy ways of accommodating people that should be part of everyday life but still aren't. The unnecessary essential criteria did apply mostly to progression. For example, in the job I'm in academia, there's a reasonable adjustment to essential criteria allowed for disabled people who perhaps can't travel a lot to conferences. That might be an expectation in the promotion criteria, that you go to lots of international conferences and do presentations. But when we talk to people, they would say, well, I can't do X or I can't do Y because of my disability, and that has essentially excluded me from promotion, and that should not be the case. It's possible to make a reasonable adjustment to that essential criteria. Then there's something we called misplaced paternalism, and we refer to this because we spoke to a number of people, particularly in the interviews, who said that once they had had a break from their job, maybe for some rehabilitation or through illness, they returned to their role and they were given very unchallenging work. And it was thought, you know, by their manager that they were being done a favour by being given this unchallenging work. But actually it meant that they couldn't get promoted. They didn't have the tools and the experience and the type of profile that was needed to get that essential criteria for promotion. So those two latter points really go together.
So we found with career progression that there was a really significant lack of disabled role models in senior leadership positions. And that's an issue for a number of reasons. One is that people who are coming into the profession have very few disabled people to look to see, well, they've been able to progress their career, they've got to the top of their profession, so that means that I can do the same thing too. But there was also the issue that if you do not have disabled people in those senior positions, in those decision-making roles, then you're losing the voice and the perspective of disabled people with those high-level business decisions that are being taken. There's a lack of diversity at the top that impacts on how well a business can do their job, basically. So it's really important to ensure that disabled people, as well as other people from underrepresented groups, have clear pathways and clear opportunities to be able to advance their careers. And this was reflected in some of the quotes that we got when we interviewed people. So when you try and meet the criteria, there's no obvious path to get you there. And I think one would have to pursue a completely different and unusual route to promotion to partnership. And that very much links to what Debbie was saying on the previous slide, is that the criteria that are usually applied for people to progress to senior leadership roles or to partnership roles, they often don't consider that those can be adjusted as a reasonable adjustment to allow disabled people to progress into those roles too. And there's no role model that I can see for somebody who's been promoted to partner in my position, you know, someone who isn't able to travel. And hopefully the experience of COVID and remote working and all these adjustments that we've had to make to working life, hopefully those will carry on in terms of finding solutions to enable disabled people to progress in future.
Okay. So disability and working practices. Working practices for disabled people were extremely important, and disabled people mainly reported they required more tailored, flexible remote working and imaginative job design. That wouldn't come as much of a surprise to anyone. but 85% of disabled solicitors and paralegals surveyed reported pain and fatigue during their working life. And really that emphasises the need for more flexible employment and, in many respects, more remote employment. A lot of people said that they could manage their impairment, their pain and fatigue, if they had the opportunity to work from home. And so, you know, those opportunities, if we can open those out, could make the workplace more disability inclusive. Disabled people frequently reported experiencing an organisational reluctance to adapt, to reform, to listen, or address exclusionary practices. And if we were to say one thing to employers, it would be trust disabled people. They know what they need. They know what they require in terms of reasonable adjustments. And normally, if you open your mind, the adjustments that they are requesting are incredibly reasonable. They're very practical. They're usually low cost. And, you know, they would actually get rid of the barriers that on a day-to-day basis a lot of people are facing. We also found an underutilisation of access to work in most areas, particularly in large organisations. Large organisations that we've spoken to and people working in large organisations have said, well, you know, we don't utilise access to work because it's one of these government schemes and we feel that we're a rich organisation and therefore perhaps we should pay for the adjustments that are made. But access to work has a lot of expertise and accumulated knowledge. And of the people we found who did use access to work, some found it extremely bureaucratic, and in that sense it was very problematic. But others did say that they felt that they'd got a lot of advice and particularly lots of technology that access to work had provided that they wouldn't have had access to through any other route. So I think access to work is an area that the legal profession could look at in greater depth and see, you know, how it could be better utilised. Billable hours. Now that won't come as a surprise that this was something complained about by a lot of disabled people who felt that they were at a substantial disadvantage when using billable hours as the main proxy for measuring performance. As outsiders, as academics, I look into this profession and think, well, these are really well qualified, well educated people, intelligent, they're bringing something to that service encounter that they're having with a client. They're bringing their expertise and their knowledge, and it's all being measured in quantitative terms rather than qualitative terms. And that seems to me to be a disadvantage for a lot of people within the profession. But to just quantify somebody's work in terms of the hours that they've worked, in particular, will represent a substantial disadvantage for a lot of people who are disabled. Okay, well, also one of the key findings was around ill treatment, bullying and discrimination. And what we found is that if you ask people if they've been discriminated against, particularly disabled people, will often say no, they haven't. And some colleagues in social sciences at Cardiff University decided to try this out by actually talking about ill treatment and bullying rather than discrimination in questions that they put to disabled people. So what they did was that they described certain kinds of behaviour which actually would constitute discrimination, but they called them ill treatment and bullying. And when they called them ill treatment and bullying, disabled people said, yes, I've experienced that. But when they called them discrimination, they often didn't admit that they had been discriminated against. And I think in itself, that's interesting that a lot of disabled people are internalising this behaviour and perhaps expecting to be treated in the way that they are being treated, which would actually constitute discrimination. And so we asked some questions around ill treatment, bullying and discrimination. And we did have 60% of solicitors and paralegals saying they'd experienced ill treatment in the workplace. And of these, 80% believed it was related to their disability. 45% of barristers surveyed reported having experienced ill treatment and 71% of these believed that this was related to their disability. So, you know, there's a high proportion of people who are actually identifying their disability as the source of ill treatment, bullying and discrimination.
So we asked on the survey for people to report what kinds of behaviours that they had experienced that amounted to ill treatment. And these were some of the key ones that came up. And there was an interesting difference between solicitors and barristers around the use of ridiculing or demeaning language. I mean, both of these are quite high, 40 to 60%. But the difference might relate to the different contexts in which solicitors and barristers work, which was quite interesting. Many people, so almost half of solicitors and paralegals, experienced exclusion or victimisation. And this was often as a result of asking for reasonable adjustments that had then not been put into place, which meant that they were having to keep coming back and keep fighting their corner and keep asking for the same things again and again. Or something was put in place that wasn't quite right, it wasn't what they needed, so they had to come back again. And they often found that that kind of was a pattern that meant that they just increasingly became excluded by their colleagues. Over 53% of solicitors and paralegals and 35% of barristers classified their experiences as discrimination. And significantly, over 80% of all groups reported experiencing poor attitudes and lack of understanding towards an impairment or health condition. So that was the main form of ill treatment, and that's employers and colleagues not understanding why people needed reasonable adjustments, or thinking that disabled people were being given favours that other people couldn't have, and not understanding that reasonable adjustments are there to address the disadvantage that disabled people face in the workplace. And that's a key area for employers to improve on, really, to improve their understanding and how they educate people in a workplace about disability and reasonable adjustments. One of the important parts of the research was the work that we did with disabled people and disabled people's networks and organisations. The disability movement has a mantra, nothing about us without us, and this applies equally within a workplace. As an employer, you can't hope to understand what the issues are that affect disabled people in the workplace, or understand how to solve some of those issues, unless disabled people themselves are responsible for identifying the barriers and prioritising the ones that need to be addressed and how they think that they should be addressed. So if you aren't involving disabled people in a meaningful way in identifying those priorities and making decisions, then you're not going to make any real progress with addressing barriers in the workplace for disabled people. But the other thing that's useful to know about disabled people's organisations is that they are led by disabled people. So they are employers of disabled people. They're very well versed in knowing what barriers that people face at work and in their day-to-day lives that can also impact on work. And they have a full understanding of the practical solutions that you can put into place to remove some of those barriers and to remove the disadvantage that disabled people face at work. And all of this supports you as an employer to help every single person in your workplace to reach their full potential. And whatever you put in place for disabled people is equally going to benefit other people in the workplace as well.
Okay, so to end on a positive note, we would like to end on some positive experiences that were conveyed to us. Some people said one of the most important things that they found was to actually see other disabled people like them in their working environment. If they saw other disabled people like them, they felt a sense of belonging, but they also felt that it was possible to, if people were at a senior level, to actually aspire to a senior role So that's really important in terms of role models. But also the presence of diversity networks. Now, there's a lot of organisations that aren't big enough really to have a diversity network, and certainly aren't big enough to have a specific disability network. And more than half of those surveyed didn't have access to a disability network. So we see a real need within the profession to either have regional networks or virtual networks established for disabled people, so that they can share experiences of disability and work in the legal profession, because that sharing of experiences and knowing that there are other people who are experiencing similar problems or obstacles to you and perhaps have found really useful and good solutions to those problems is, really, really important. Access to mentors and participating in reverse mentoring schemes was one area that people said had really helped. The problem being that access to mentors is difficult. There are some organisations like City Disabilities, which was established by Robert Hunter, previously of the LDD, but also, he's been a partner in a firm and identifies as a disabled person. I mean, he set up City Disabilities to provide mentors within the City of London. Outside of London, we didn't see any established mentoring schemes. However, we are aware that the Lawyers with Disabilities Division have had an informal mentoring scheme over the years, but we'd like to see much more organisation of mentoring and reverse mentoring as well, with the caveat that reverse mentoring does involve disabled people mentoring senior colleagues, and where that's been successful, it's really enlightened senior colleagues of the day-to-day problems that a lot of disabled people can encounter in the workplace. But the caveat is that this can't become a responsibility of disabled people to educate everybody within the workplace about disability and not actually be rewarded for that participation. Going back to the billable hours, we had a few examples come to us about things like reverse mentoring or being a disability champion within the workplace, being allocated a certain amount of billable hours. That's one way forward for firms to really think about improving this inclusive role and actually rewarding disabled people for getting involved in it. But, overall, what needs to be addressed is that career trajectory, people getting into the more senior positions, so that decision makers at the top are identified as disabled, but also seen as role models, mentors, and, offering a positive future for people within the profession.
Hopefully you already have seen the research reports, but you can find them on legallyddisabled.com, our website, and also the resources that follow on from that, and also the presentation slides from this presentation will be up there as well. We will move on to Jane Burton, who is the chair of the Lawyers with Disabilities Division, to talk about their experiences of working in co-production with us. So I'll hand over to Jane now. Thank you.
Thank you, Natasha and Debbie. The Lawyers with Disabilities Division were delighted to be approached by Debbie and Natasha. We knew the problems our members were experiencing, but until this project, we had no concrete data and research to back this up. There was a huge gap. Other diversity strands within the profession had research that backed up their experiences and helped their causes. And over the course of the research, we had frequent meetings with Debbie and Natasha. They listened to what we had to say, and they were very open to our suggestions. We felt the fact that they both had their own lived experience of disability made working together much easier, as we didn't have to explain what the problems were, they understood. The findings in the research report are having a very positive impact in raising awareness within the profession. Non-disabled people within the legal profession have been shocked by what they have read about the experiences of disabled professionals, and they are now much more willing to really engage with us and help us campaign for real change. Until this research was published, we had been on the outside of diversity policies. Just one example of the positive impact of the report has been the Law Society Gazette. Prior to this, the Gazette published one article a year on disability, usually a profile of a high-profile disabled solicitor. And at the time of the research launch in January, there were 3 articles in 2 days, which is a record. And since then, they are now regularly featuring articles about disability and the legal profession, and approaching LDD for comment and content. So we owe a huge debt of thanks to both Debbie and Natasha for doing this research. Thank you.